name is Maggie LaBranche Gonzalez, and I'm an attorney with Litherland Kennedy & Associates. We're an estate planning and elder care law firm located in sunny Campbell, California. Today I want to talk to you about the importance of funding your trust. Whether or not your loved ones avoid the nightmare of probate really depends on your continued diligence in making sure that all of the assets that you own now and acquire in the future are transferred and titled in the name of the trust. So what is funding? Funding is the process in which you retitle your assets in the name of the trust. These can be your community property assets or your separate property assets. In California, the limit of assets you can hold outside of the trust is $166,250. Assets that have a joint owner or a designated beneficiary do not count towards that limit. So what kind of assets should you be titling in the name of the trust? Well, real property. This is real property that you own either by yourself or with others. Maybe you own a piece of property with your sister. You can transfer your interest in your trust. Bank accounts, brokerage accounts, stocks, those sorts of assets should be titled in the name of the trust. There is a major exception. The major exception is all of your retirement plans. So 401ks, IRAs, those sorts of assets should not be titled in the name of the trust. Why? The IRS considers that an immediate taxable event. It's as if you have just cashed it out and now you have to pay taxes. We don't want to do that. So in this case, you would update your beneficiary forms. Now, there are a couple of misconceptions I hear frequently about funding your trust. First, simply having a trust is not funding your trust. That's right. You are going to need to do additional work in order to fund your trust after you've created your trust. 2, simply listing all of your assets on your Schedule A, B, or C is not funding your trust. That's just a list of all of the assets you own at that time. It is important you keep that up to date. Why? Your trustees need to know where all of your assets are. 2, if you have an updated Schedule A, B, or C, if something is not titled in the trust, falls out of trust, doesn't have a joint owner, or there is no beneficiary designated, your trustees can get to court and have it put in the trust. 3, that's where your pour-over will comes into play. A lot of times people say, yeah, but I have this pour-over will. The pour-over will is simply a safety net. We don't want to have to use it unless we absolutely have to, because it still involves going to court. It is a probate process, albeit maybe not the full-blown process. So the bottom line is you more than anyone else determine the effectiveness of your trust by making sure it's properly funded. If you found this video helpful, please hit like and make sure you subscribe. Thanks!